So I'm Georgia, the director of Life is Too Short. So within Life is Too Short, what we do is we look after individuals and businesses in all aspects of estate planning, protection and mortgages. On the estate planning side, we do everything from wills, trusts, lasting powers of attorney and business lasting powers of attorney. On the protection side, we look after business protection, so shareholder protection, relevant life, key person, and then all your normal protections such as life insurance, critical illness, health insurance, employee benefits, all of those things. And then on the mortgage side, we do buy-to-lets, first-time buyers, remortgaging and equity release as well.
So what is an LPA, Georgia?
So a LPA stands for lasting powers of attorney. There's two types of lasting powers of attorney that you can have personally, and then there's also a business lasting powers of attorney. The first lasting powers of attorney in a personal essence is health and welfare. So allowing somebody to look after you regarding your health and welfare decisions. And this is regarding incapacity. So if you lose capacity, who can act for you? You've then got the second type of personal lasting powers of attorney, which is property and finance. So trusted people to be able to look after all of your finances, bills, dealing with banks, and then all of your property as well. And then you have the business lasting powers of attorney. So again, finances, any properties within business, everything financial regarding business decisions, everything from, signing off loans, accounts, payroll, and everything in between.
So maybe with an example, why would someone need an LPA?
So the common misconception with LPAs, and obviously they are to deal with incapacity, so not death. A lot of people will talk to you about wills and LPAs because a will is to deal with your death. Lasting powers of attorney is to deal with when you're still alive, but you lose capacity. A reason why people kind of think that they're with the older generation is probably because that's kind of a lot of the time when people actually use them. Because, if you, for example, got an awful illness or a stroke or things like that people will then step in. But actually a lasting powers of attorney needs to be dealt with anybody over the age of 18. One of the reasons that you would need a lasting powers of attorney is simply to, manage your life. So, for example, if you have a single bank account, so you are married or you're not married, and you've got a bank account in your name, your partner, your loved ones can't access that bank account. It essentially freezes if you don't have a lasting powers of attorney in place. On the health side, for example, if you need to turn off a life support machine or there's any certain medical decisions or care, if you don't have lasting powers of attorney in place, no decisions can be made there. And a misconception is that if you're married, you have these, rights already, which is not true. You need this irrelevant if you're married, if you're not married. And another misconception is that if people have a joint bank account, that you can still, access everything because you're both named on the bank account, which is true in a sense, but not fully. So even if you're on a joint bank account, if one of you loses capacity, yes, you can still withdraw money, you can still, manage the bank account in a sense, but the bank will still monitor it and they can still temporarily freeze it as well. So lasting powers of attorney are really, really important for absolutely every single person, in the country, simply because everybody thinks that just because you're married, you have these rights. You do not. Just because you're, the daughters, sons of these people, you do not have these rights. Even if you have joint bank accounts, you do not have these rights. And then also on the business side, essentially, if you do not have lasting powers of attorney, if you have a director in the business who deals with all of the payroll, or is a personal guarantee to a loan or anything else like that, essentially the business can completely freeze if they lose capacity. So you have no right to do any of those things, and your business will stall overnight if a business lasting power of attorney isn't put in place.
So you couldn't even pay people's wages in that situation?
Cannot pay wages. Essentially the business freezes overnight if you do not have lasting powers of attorney. And even if, for example, you've got a couple of people on the joint bank accounts or a couple of people who can access the payroll, again, it's the same principle within the joint bank account. Personally, the bank can still heavily monitor it and still temporarily freeze it as well. But in a lot of businesses, there is only one person who pays payroll. There is only one person who deals with all of the accounts. So yeah, it can essentially kind of stall your business overnight from losing capacity with that person.
I've got so many questions that are pinging around in my head. And what can we go back a step? So what physically is it? Is it so a will has to be in a physical document? What is an LPA like a contract?
Yeah, so a lasting powers of attorney is essentially a physical document as well. You have to, again, another misconception about lasting powers of attorney is that if you've done them, that's okay. You actually have to have them registered with the Office of the Public Guardian for you to even act as a lasting powers of attorney. So a lot of people get their lasting powers of attorney drawn up, and they nominate their kind of said people who they want to support them with health, finances, property, or in business. But if you do not register them with the Office of Public Guardian, you cannot do anything, and that process can take up to 20 weeks as well. So it's always advised that as soon as you get them drawn, that they are actually registered immediately, because otherwise what you don't want to do is be in a situation where somebody's lost capacity and then you're having to wait for them to actually be registered, and then you're kind of in limbo for up to 20 weeks whilst they're being registered.
In a personal situation, say for instance that somebody's gone into hospital for an operation and then things don't necessarily go the right way and they are then what's considered incapacitated, will the doctors give you information about that situation if you don't have lasting powers of attorney in place?
They will give you information, but they won't allow you to make decisions without lasting powers of attorney. So a lasting powers of attorney is about the legal right to make a decision. So even though they may give you information, you cannot make any decisions on that situation. And that is the power of it, is that you are able to control the situation and support your loved one in that situation. So yeah, it's you will get information, but you won't necessarily be able to actually make any decisions.
Thank you. So and you can't do it in retrospect once somebody, because what would happen then in that situation if you haven't done it, because you haven't done it ahead of before you needed it? When you do need it, what happens then?
So the person has to have capacity to draw up a lasting powers of attorney. It's the same for will. You have to have capacity to do so, because otherwise, it is open to misuse and manipulation. So you have to have capacity to draw up a lasting powers of attorney. So you cannot do these things in retrospect in that way. It has to be preemptive when somebody does have capacity.
So what point in our lives then is a good time to do that? Because isn't it just for older people?
No. Well, the younger the better. So as we all know with life, it can throw some real curveballs at us. Essentially, anybody over the age of 18 needs a lasting powers of attorney. But what I kind of, recommend to people who absolutely need lasting powers of attorney are anybody who is in a long-term relationship, especially if they have separate bank accounts. Anybody who has an income protection policy or a critical illness policy, because the way that works is that the income, if you, for example, are off on long-term sick, or you cannot work because of an incapacity, and you need that income protection policy to support your monthly bills, and that pays into your personal bank account, nobody can access that money to pay those bills if you don't have lasting powers of attorney. And it's the same with critical illness, that will pay into your personal bank account. So again, nobody can use that money if they don't have a lasting powers of attorney over your finances to access that money to support you. So anybody with income protection, anybody with critical illness, anybody who's in a long-term relationship, anybody who's got a mortgage. So you need a lasting powers of attorney to, even if you're kind of, again, joint named on the mortgage, again with bank accounts, managing the property itself, or if you're with somebody who has a separate property, you can't manage that property, and especially anybody who has children, mainly because you would need to access all of the finances to support your family. You need the full power to do that, to look after your little ones. So yeah, really anybody who's got any kind of real responsibility, and needs to care for somebody in terms of a partnership, in terms of, they're living on their own and they've got bills to pay, has property, has young children. So yeah, basically nearly everybody in our population.
Okay, how would we decide who we're going to name as an attorney?
So attorneys need to be your trusted people. So in a personal sense, for example, you need to be choosing people who, firstly, you absolutely trust to make the right decisions. And that might be, family. That might be your children who are over the age of 18. That may be a very close family friend or personal friend. But it needs to be somebody who you actually trust to make the right decisions, because they will have control over your health and your finances. So, for example, you also may have people who you trust with your finances, but you might not trust with your health. Or you just, not that you don't trust them, but you just want other people to make decisions. So what we see typically is, family members are on the health and welfare lasting powers of attorney, and then you may have a partner or a very trusted friend on the finances. But they need to be somebody who you absolutely trust to make the right decisions for you, for your family, for your care, for your finances, to give that authority away.
So if I had personal health and welfare LPA in place, and I had my personal finance LPA in place, and then I had a business LPA in place, do any of those cancel each other out, or are they all very separate?
They're all very separate. So with, for example, the business finances, what you would normally see is if you're in partnership with other people, then those fellow directors would, deal with the finances. We also have a lot of sole traders who take out lasting powers of attorney via their business, and they may have, a partner or another employee, so that the inner workings of the business can still happen. And then, health and welfare is very, very separate, and your personal finances are very, very separate. The banks will not allow you to have a personal LPA on your finances and then go and deal with the business bank account if those people aren't named on that business lasting powers of attorney. So they're completely separate documents and will be seen as separate issues.
Fab, thank you. How is a business LPA different from a personal LPA?
So a business LPA is very similar in terms of a personal property and finance, but with business LPAs, you only have a property and finance LPA. So you don't have a health and welfare, for example, but it is to specifically deal with everything regarding that business. So whether you're a sole trader or a limited company, that gets, identified for those specific things, where a personal is anything with your personal name on it, because obviously with a business LPA, you'll the majority of the time you'll have the business bank account name on there, not a personal name on there.
Fab, thank you. If I had multiple businesses, would I need to have separate LPAs for each business?
No, you can have one LPA for all of the businesses. So it's an all-encompassing business LPA, and that can be written in within the LPA. So technically, you still only need one, but the businesses are listed, so that is identified.
So when does an LPA take effect?
The LPA, so there's two different ways it can take effect, and you make that choice when you write an LPA. The first one is kind of immediate, before you lose capacity. So that's one option. That's normally the recommended option as well. So, it can effectively take as soon as it's registered, it can take effect, and you can call on those people if you need to, or you can choose to only when you lose capacity. So there is two different ways, but you make that choice when you advise.
So does that mean if I activated that immediately, does that mean they could make decisions for me when I didn't want them to?
So yes and no. So with the health and welfare lasting powers of attorney, they cannot act until you lose mental capacity. With a property and finance lasting powers of attorney, they can act. There are safeguards that are put in place, but also in the way that you set up your lasting powers of attorney, you have jointly and severally, or severally. And what that basically means is, do they all have to work together, or can they work separately, or can they work together and separately? So depending on kind of your setup as well, it creates some certain safeguards. But yes, essentially with the property and finance, if you have chosen the option to, be able to act before you lose capacity, and then depending on the options, whether they're jointly and severally, or just severally, they can technically act, but there are certain safeguards built around that as well.
Can I choose more than one attorney?
Yes, you absolutely can. So there's a couple of things here regarding kind of choosing who you choose. So if you are a couple, in whatever capacity you are a couple, we always recommend that they, again, this is a choice by people. Some couples may not want this, but what we typically see is that the first attorney is the other partner. And you absolutely have to name them. It's not like a will where it's kind of embedded that it passes to each other with a tick of a box. It's actually, you have to physically name them as your first attorney. You then have 3 additional options as first attorney. So these are the first people that will be called to act. So some people may, fill all of those boxes up and have, you can technically have more, but we kind of recommend that no more than 4, because it kind of becomes also a little bit complicated. So you can kind of choose more. And then you also have reserve attorneys as well. So again, some people don't name reserve attorneys, and what a reserve attorney is if any or all, again, these are options, but if any or all of the attorneys, the first attorneys, cannot act, then the reserve attorneys can step in. So you can, again, have no reserve attorneys, or you can have multiple, but again, we kind of say don't choose more than 4, because again, things can get quite complicated in that situation. But a lot of people kind of maybe choose between 2 and 3 attorneys to support, and then maybe have 1 backup reserve attorney. It depends on your family, but yes, you can have multiple attorneys. I think the important aspect here is, have you got the right attorneys? Have you got the right first attorneys? Have you got the right reserve attorneys to be
Can they say no if I ask them?
Yeah, they can. So what actually also happens in this process is, obviously, we always recommend that people have a conversation with the people they want to choose to be attorneys before they start drafting a lasting powers of attorney. But actually in the process, when you register them with the Office of Public Guardian, the Office of Public Guardian contacts every single attorney, and they give them a month to make a decision on whether they are not happy to be an attorney. So yes, they can absolutely say no. Also, there's it's quite important that you make sure you have those conversations first, and that you speak to those people before you draw up your lasting powers of attorney, because unlike a will, where a lot of the time, especially if you've got them in storage, you can update them, and that may be a small cost or no cost at all. With a lasting powers of attorney, if you need to make any changes, you have to redraft completely. So it is really kind of important that people make the right decisions and have spoken to all of those people before they go and send off to the Office of Public Guardian and they draft those documents, because obviously it can be costly if you need to change it all again. There are updates, but again, it is a cost, so, and much more than you would deal with a will. So yeah, it's very important that the right attorneys are chosen, that you have those conversations with those people. And also, I think that that's important to have those conversations with those people before you draft it, because you also need to kind of imprint on them the importance of their role. Because a lot of the time with lasting powers of attorney and the attorneys themselves, in certain situations, they need to be physically present. So, for example, within my family, my siblings are, most of the time around the world, and that would cause a problem in certain aspects of being an attorney, because you physically need to be there. You physically need to show proof of ID to prove who you are. So again, that's a real consideration that people need to make. Are they in the country? Can they be in the country quickly if they're not in the country? And can they, show up to do what you need to do? So it's really important.
So Georgia, how would we find out any more information? Do you give any guidance on how to deal with the LPAs?
Yeah, absolutely. So on our website, lifeistooshort.co.uk, so that it's life-is-too-short.co.uk, just for anybody else. Apologies, it's a bit of a mouthful. So we actually have dedicated packs of education around this. So we have an LPA pack, an attorney pack. And in that it is, frequently asked questions, key information that you would need, and kind of everything around actually properly informing you. And you can kind of keep it for yourself so that you can read that, or you can send that on to people who you are having a conversation with about being an attorney. Also, we have a blog with frequently asked questions in there as well. And again, we've kind of covered all topics, so you can kind of put something in and you'll be able to find that answer. But also, you can ask us questions, and also you can book directly in with our advisors onto our website as well. So if you just wanted to have a 15-minute call where you just, shouted some questions and said, in this situation, this happens, I'm thinking about these people, do you think that's a good idea? You can book in a call with an advisor as well to kind of have somebody to sound board against.
That's amazing. Thank you so much, Georgia. Really appreciate your time. That's been brilliant. Thank you.